On the record in the matter of the people of the city of Lansing versus Rambo L, file numbers 22L2761, 882, 881, 883. Council appearance, please.
Matt Staples on behalf of the city of Lansing.
Okay, and then Rambo L is present. Do you have an attorney, sir?
I'm here by special appearance.
Okay. Mr. Staples, my understanding is that you're moving to dismiss these.
Just the failure to display ops, Your Honor. I did check the Secretary of State. His license is valid, and he did show me that license, and that he does have it in his possession, so that the misdemeanor charge would be dismissed.
Hey everyone, welcome back to the channel. Today we're diving into a right to travel sovereign citizen trial I've been waiting to wrap up so I could bring you the full story with proper context. This case comes with 3 separate appearances, each more chaotic than the last, and all leading to one final outcome that's genuinely satisfying to watch unfold. Now that everything is complete and the dust has settled, it's the perfect time to walk you through the entire sequence. Let's get started.
Okay, and there's no offer on the expired plate and the failed signal?
Not at this time, Your Honor. I believe
Okay.
Mr. L is planning on contesting those charges.
Is that correct, Mr. L?
Yes.
Okay, we'll set them for a hearing. February 14th at 9:30. Any additional matters for the record, counsel?
Nothing for the city, Your Honor.
Okay, you're all set, Mr. L. We'll see you on February 14th. Okay, is this L Rambo or Rambo L? You're muted. You have an attorney, sir?
No, I'm here by special appearance.
Okay, I'll put you in the private meeting room with the city attorney.
Your Honor, we've actually already met with Mr. Rambo L before. He was requesting a formal hearing on these 2 files.
Okay, sounds good. Formal hearings will be set for in-person appearance.
Actually, I filed a motion January 6th. Is when it went unanswered. I would like the court to dismiss this matter.
Okay, your motion to dismiss is denied.
Wait a minute, did you just confirm that he actually has a valid driver's license? If that's the case, then every right to travel argument he's been pushing instantly falls apart. By holding that license, he's already agreed with the state's position that operating a vehicle isn't an inherent right, it's a regulated privilege. It's a contradiction so big that the courtroom can't ignore it, and it undercuts the very foundation of the claims he's been trying to make. Next.
How many days does the prosecutor have to answer my motion for motion for challenge of jurisdiction that I submitted to the clerk, and I've served everybody, all parties? How long does he have? Because that happened January 6th.
I see it's a motion to show authority.
And also a demand for dismissal, lack of jurisdiction, failure to introduce evidence of an injury in fact, challenges jurisdiction of the court to prosecute. That was filed January 6th.
We only have one motion attached to the file. I don't see the other motions that you're referencing, sir.
It's timestamped by the court. I have it right here.
I see a motion to show authority, which the court has denied. And then there was a memo that was attached. There was not any other motion. I don't read via Zoom.
It may have been completely ineffective, but I have to admit his attempt to file a motion to dismiss the case, despite having absolutely no legal basis for it, was something to behold. The courtroom watched as he presented a request built on air, hoping confidence alone would carry it through. Instead, it served as yet another example of how these arguments collapse the moment they're tested by actual procedure.
It's filed with the clerk. Everybody was served.
Mr. Staples, did you get a copy of the motion he's referencing?
I see a copy of the motion to show authority in our file. I don't recognize it as any sort of valid motion or pleadings. but I see a copy of it in our file.
Agreed. That's the same the court has. It's a motion to show authority. The other motions that he's referencing was not properly filed with this court or served as the court, neither the court nor Mr. Staples' office is in receipt of it. The motion to show authority was denied, is not in proportion with the Michigan court rules. It does cite, however, Luke 11:46, the King James Version, Luke 11:52, as well as some other articles and treaties.
Fortunately for you, Judge, we actually do have the paperwork right here. So let's take a closer look at what he submitted before it becomes today's lunch. The first thing that jumps out is that this document isn't a motion at all, it's a notice. And a notice is exactly what it sounds like. A statement informing everyone involved in the case about something you intend to do. In this situation, it's a notice of his intention to request a dismissal based on the reasons he scribbled on the page. But here's the problem, where is the actual motion to dismiss? Without filing that, all he's done is alert the entire courtroom that he doesn't understand the process he's trying to use. It's a textbook example of how sovereign citizen paperwork looks official on the surface but falls apart the moment you check what it actually does.
But nonetheless, as indicated by Mr. Staples from the Office of City Attorney, this is not a lawful or appropriately filed motion. And for that reason, it was denied before this court. But we will
Well, I
set
like
your
to
matter.
challenge jurisdiction right now. I have the right to
You can file an
travel.
appropriate motion with the court under the Michigan court rules to challenge jurisdiction. But what we won't do is entertain motions under the King James Version of the Bible. Okay?
That was a different motion you're referring to. That was the motion to show authority.
We don't have the other motion, sir. So you can file that motion. It's just, we don't have it. I don't know why we only have one motion, that we don't have the other one you're referencing. So you'd have to file that and serve it on the city attorney. We'll give you time to do that. I'm gonna set both of these matters for hearing though.
I can't chill. You telling me I don't have the right to challenge jurisdiction right now? I want to challenge jurisdiction right now.
You can file a motion for challenging the jurisdiction, sir.
I can't do a verbal motion?
No, you cannot.
So you telling me I don't have the right to do a verbal motion?
You don't have a right to do that. You're gonna file it in writing and you're gonna serve it properly on the parties that you're filing it against. Okay, sir? March 14th at 10:30 in person at the court will be the date for the formal hearing, and then we'll hear any arguments on motions if necessary. You have any questions today, Mr. L? Okay, well, then you're all set. Thank you.
It seems our defendant has decided that the Michigan court rules are taking a back seat today, replaced by what appears to be his own personal version of King James court procedures. In other words, he's trying to run this hearing based on a set of rules that exist nowhere in law, only in his imagination. The courtroom takes notice immediately, recognizing that this shift in authority is about to create another round of confusion. It's yet another example of how sovereign citizen interpretations attempt to override real procedure, and unsurprisingly, it's not going to fly here.
Okay, you can have a seat. Thank you. Today's the date and time set for a formal hearing. I have, I believe, one witness on Zoom. Counsel, you can proceed.
Officer Vanderwerf, would you state your name for the records,
Oh,
please?
you want to call him? Let me.
Oh, I'm sorry.
Swear, man, no worries. Vanderwerf, can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Judge.
All right, that brings us to the third and final appearance from our defendant, also known, at least in his own filings, as First Blood L, King James edition. This is the moment where all of his previous arguments, aliases, and improvised legal theories finally come together. The courtroom is more than ready to hear how he plans to wrap this up, and it's clear everyone is bracing for another unconventional performance. Let's take a closer look at how this last appearance plays out.
So I was traveling southbound on King when I observed a pickup truck in front of me that was changing lanes, failing to use its signal. So at that time, I activated my overhead lights on the vehicle to initiate a traffic stop. And then I made contact with the driver, who was later identified as a Rambo L. In our contact, he ended up handing me a piece of paper. At brief glance, when I looked at the piece of paper, it appeared to have what I believe was certain MCL codes that the subject may have typed onto the piece of paper. When I had asked him for a driver's license or identification, he was not really very cooperative. I also don't believe I was provided any insurance. At that time, I decided to issue him a citation for failing to signal, changing lanes, and failing to display a valid license. And then also the license plate went through the system was expired.
Mr. L, did you want to question the witness?
Yes. The document that you were referring to, it was a travel document. I was showing you, I was traveling versus driving, and I tried to explain that to you. And then you held me on the side of the road for approximately an hour. I requested a supervisor because they might better understand what I was doing, and you never provided that for me. Is that correct?
That's actually incorrect, because the reason that you were held on the stop for as long as you were is because I was waiting for a supervisor. So when I realized the supervisor was not there, I contacted him by phone, at which time he said he was delayed. And when I came back up to the traffic stop, I did ask if you wanted to wait further for a sergeant, and I don't believe that you did. And then you drove off when you were free to go.
Yes. Is it correct that I was held on the road for approximately an hour waiting for this whole encounter to end?
I do not remember if it was an hour specifically, but I do remember that the time length was probably, I would say probably close to that at the very least.
Well, it was an hour, and it caused me to be late for my son's banquet.
To keep things moving, I won't drag you through the full back and forth between the prosecutor and the officer who pulled over Sylvester Malone Elbay. Instead, I'll spare you the routine details and focus on the key points that actually matter. This way, you get the crucial information without the filler, and we can move straight into the moments that shape the outcome of the case.
And and I never got to speak to a supervisor. That's all the questions I had.
Okay, any redirects?
No redirect, Your Honor.
Okay, any additional witnesses today?
None from the city.
Okay, Mr. L, are you calling any witnesses today, or did you want to give your own testimony?
I would like to, I have some, I have a defense, my
Well,
motion.
Okay, well, you filed a motion?
Yeah, I filed a motion, served the
When did
city
you file a
attorney.
motion?
It was filed, it was mailed February 18th.
You filed a motion and mailed it February 18th. Did you serve a copy?
To the clerk of the courts and also to the city attorney's office.
Did you receive any motion, sir?
Your Honor, we did receive a motion. It did not have any hearing date stated on it. We had no timetable for a response. I would be happy to respond to the motion on the record orally or provide the court with briefing if they would like.
The court didn't get a copy of the motion in February.
I sent it to the clerk.
Yeah,
And,
typically when that happens, it's just attached to the file. I don't have a copy of any motion.
well, I did my due diligence. I sent a copy to him. He has his.
Well, I don't know that you did your due diligence, because when you file a motion, you got to get a hearing date for that motion. And so
Who's supposed to give me a hearing?
you got to get the hearing date from the clerk's office.
From the clerk's office?
Yeah.
So why did they give me one?
Did you contact them for a hearing date?
I contacted them, yeah.
And ask for
And
a
I
hearing
asked
date
them,
for your
and I
motion?
asked when my hearing, they confirmed that it was today.
For your motion.
And I asked, did I have a hearing date? And they
But-
said,
And you do have a hearing date, but that's not what I asked you. Did you ask them, did you have a hearing date for your motion?
So it sounds like he's trying to blame the officer for a situation that stemmed entirely from his own choices. Instead of simply following the law and getting on with his day, maybe even making it to his son's banquet, he chose to dig in and stand on a belief system that has no basis in reality. And the officer made it clear in his testimony that the delay only grew longer because he asked for a supervisor. In other words, the setback wasn't created by law enforcement. It was the direct result of his own decisions.
for my motion,
Yes.
They didn't tell me, but I did provide to him an order for the motion that gave him 21 days to respond.
Okay, you can make your motion before the court because I don't have a copy. You can make it now orally.
Okay, well, now comes the beneficiary for Rambo L, defendant in error, here by special appearance, not submitting to the court's jurisdiction, hereby moves the court to strike and dismiss the complaint filed by the officer Zinderbar. Am I pronouncing that right? Sorry if I'm not. For lack of ratification and commencement, no corpus delicti, no plaintiff, lack of jurisdiction, personal firm jurisdiction. Christina Simmons being appointed as trustee, the prosecutors being appointed as co-trustee, I, Rambo L, an executor and beneficiary of a set of account. Also, I filed a declaration of non-citizenship nationality because I've done a name change.
This is exactly where representing yourself becomes risky, and why I always stress that hiring an attorney is almost always in your best interest. Court procedures aren't nearly as simple as they look on TV. Shows like Perry Mason make it seem like you just walk in, say a few dramatic lines, and everything magically falls into place, but the real process is far more structured. Here in Michigan, filing a motion is only half the job. You also need to submit a notice of hearing, typically attached to the motion, and serve it to all parties involved. Only after that will the court schedule a hearing date, and that's when your motion is actually addressed. Most courts give a lot of flexibility to self-represented litigants, and this judge is no exception. They're willing to hear his improperly filed motion today, even though it doesn't meet the usual requirements. But despite that courtesy, the outcome isn't going to change. The process matters, and no amount of procedural shortcuts can rescue an argument that was flawed from the start.
My point of authorities are the United States District of Columbia Corporation in Volume 20, Corpus Juris Section 1785. We find United States government as a foreign corporations with respect to the states. Since the corporation is a fictitious person, it can't see, speak, smell, or touch itself. It's a fiction in the real world. It needs a conducting, transmitting utility, a liaison, some sort of connection to a fictional person. Constitutional Amendment number 1, Congress shall make no law respecting an establishment of a religion, prohibiting free exercise thereof, abridging freedom of speech or right of press or right of people, peaceful assemble, petition the government for redress of grievance. Number 5, Constitutional Amendment. The right of people should be secure in their person, houses, papers, in effect against unreasonable searches and seizures shall not be violated, and no warrant shall be issued upon probable cause supported by an oath or affirmation, particularly describing the place search of a person's things to be seized. And then number 7, Constitutional Amendment, suits at common law where value of controversy exceeding $20, the right of a jury trial shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States according to the rules of common law. I asked for a jury trial, I didn't get that.
Come on, this reasoning doesn't even make it to the starting line. First, changing your name does not revoke your citizenship. That idea isn't just incorrect, it's nowhere near the legal standard. Second, in Michigan, a name change requires filing a petition with the circuit court. And here's the key point. The circuit court's authority comes directly from the Michigan Supreme Court. That same hierarchy is what grants jurisdiction to the district courts as well. So if your argument is that the district court doesn't have jurisdiction over you, then by your own logic, the circuit court wouldn't have had jurisdiction to approve your name change in the first place. It's a perfect example of an argument folding in on itself, trying to build a loophole that ends up wiping out the very paperwork you rely on.
Rambo L is a man, people, but not a person. I was not operating in commerce, nor was I a driver on the road for travel. A driver is an employee transporting goods or passengers. Rambo was just merely traveling in my private property. Here are some examples of my Supreme Court constitutional defenses. Number 1, case number 1, the right to travel is part of a liberty where where a citizen cannot be deprived of due process under the Fifth Amendment, Kent versus Duels, 357 U.S. 116, 125.
Not quite. While Article 1, Section 14 of the Michigan Constitution does provide for jury trials in civil cases if one party properly requests it, that protection does not extend to civil infractions. There's no Michigan statute or court rule that guarantees a jury trial for these minor civil matters. In other words, the law draws a clear line between standard civil disputes and civil infractions, and claiming a jury trial for the latter simply isn't supported by Michigan law.
Case number 2, I have the right to travel freely and unencumbered pursuant to Shapiro versus Thomas, 394 USP 618. That right is so basic, it doesn't even need to be mentioned. The state of Michigan arbitrarily and erroneously perverted my right into a privilege and issue a license and a fee for it. Murdoch versus Pennsylvania, 319 U.S. 105. Supreme Court trumps everything, says that no state can convert a secured liberty into a privilege and issue a license and fee for it. Case number 4, Shuttle versus Birmingham, Alabama. It shows that I can ignore a license and engage in the right with immunity. Case number 5, Marbury versus Madison, 5 U.S. 137, shows that any law in violation of the Constitution is null and void. Case number 6, Shuttleworth versus Birmingham, 373 U.S. 262, says I may ignore the license and the fee and engage with the right with immunity. That means you can't punish me. And United States versus Bishop defines willfulness as an evil motive or intent to avoid a known duty, task under the law, with a morality certain. I submit I couldn't have been doing an evil task. I totally followed the Constitution in the Supreme Court. Bryers versus United States says it shows how the judge is supposed to interpret the Constitution, and it's supposed to be interpreted in the favor of me. A.M. Jurisprudence, Volume 16, Section 97 of the Constitutional Law section says it should be received as a liberal interpretation in favor of the citizen, especially true with respect to those who were designated to safeguard the liberty and security of a citizen in regards to both persons and property. See note 31, Bryers versus United States. No state may convert a liberty into a privilege. Murdoch versus Pennsylvania. An appearance ticket is not accusatory instrument. It doesn't confer jurisdiction over the defendant. People versus Gabay, 670 New York 2D 92517. I was not engaged in a commercial trade at the time of the alleged infraction, and I do not proceed to say a license is upon a constitutional detention. Motor vehicle means every description of a carrier drawn by mechanical power used in commercial purposes on a highway.
Some of you might recall that in my last video, I briefly touched on Kent v. Doles. Just to clarify, this isn't a case about driver's licenses or vehicle registrations. It's about a passport denial, allegedly based on political discrimination. That makes it completely irrelevant to what's happening here. The same goes for the next few cases he's likely to cite. I'll let him run through his entire string of legal references first, then break down why each one fails to support his argument. By the end, it becomes clear that he's trying to apply unrelated case law to a situation where it simply doesn't fit.
And then there's neither injury nor trespasses, any trespasses. All crimes are commercial, 27 CFR 72.11, and every alleged crime has to have a nature and cause and be prosecuted by the name of the people of the state. I don't have a contract with the state.
You've already handed over your driver's license to the prosecutor. Even by your own highly mistaken view of how the judicial system works, that act alone shows you've entered into a contract with the state. In other words, the very thing you're trying to argue against actually proves that you've agreed to follow the rules you're now attempting to challenge. It's a clear example of how actions speak louder than misapplied legal theories.
I don't see an injured party. I don't know why I'm here.
Any additional Argue on your motion.
I would like the court, I would ask the court to dismiss this for failure to state a claim where relief can be granted.
The court has heard the argument. I'm first address your motion, Mr. L, and I'm going to deny your motion as clearly indicated in the response by the city. Your claims would be most appropriately brought before the Court of Claims, and so you can't challenge a constitutional issue in this court, okay? As it relates to the authority and the process to bring this matter before the district court as it relates to your civil infractions, you have an expired plate and a failure to signal. Again, a jurisdiction or venue before this court is appropriate. This is a situation or incident that occurred in the area of South MLK Martin Luther King Boulevard. That's in the city of Lansing, Ingham County, state of Michigan. And so you're subject to the laws and the ordinances of the city of Lansing, but also the laws under the Michigan compile laws. Here in this district court, we are subject to the Michigan court rules. And so although I gave leniency with your motion, it was not properly filed and or served. But it also does not comport with the Michigan compile laws or Michigan court rules. And so for those reasons, it is denied. Now, as to the civil infraction, failed to signal an expired plate from December 3rd, 2022, we do not provide any valid dispute or defense to these civil infractions. You could have appeared and showed information that demonstrated you did have a valid plate at the time, or that you even have one now, which could reduce the citation, but that's not taking place. And so I'm going to sustain both violations of civil infractions. There's a fine of $125 on each. Okay, sir?
My next defense, am this done or can I say something else?
You can say something else. I asked you if you had any further defense, but you said.
My next defense would be, Michigan allows 72 hours to register any vehicle when it's first purchased. He never asked for anything. I never got a chance to explain myself on the side of the road.
Okay, do you have proof that you had just purchased it within 72 hours?
I don't have the title.
Okay, thank you, sir.
We always say that arguing your case on the side of the road isn't the right place for it. That's what the courts are for. And yet, here he is in court, claiming he shouldn't be held responsible because his car was recently purchased and supposedly fell under a 72-hour grace period. The problem? He failed to produce a court-approved transaction record, a bill of sale, or any credible evidence to support that claim. In other words, the defense he's presenting doesn't hold up under scrutiny, and the courtroom can see right through it. His argument collapses the moment it meets the legal standard.
If the defense is not meaningful, if you can't provide any evidence to support that defense. That being said, your fine is $125 on each file. When do you intend to make payment?
Do I have a chance to appeal this?
You can.
I would like to appeal.
Okay, you want to file an appeal? It's the civil infraction?
I want to file an appeal today.
Okay, you can file a motion for reconsideration. But you need to follow Michigan court rules, okay? We don't submit to the sovereign rules, okay? You take that to the sovereign court.
I can't help but appreciate how the judge just tells him to take it to sovereign court, a place that, in practice, functions more like a daycare for adults convinced they're above the law. And with that, we're wrapping up today's video. It's no surprise that the sovereign citizen arguments fall apart once again. If you enjoyed watching this courtroom chaos, drop a like. If not, a dislike works too, but don't forget to leave a comment, subscribe, and turn on notifications so you don't miss any of my upcoming content.